My name is Nick Gebelt. I'm a bankruptcy attorney here in Whittier, California, and I've been making a series of videos on Chapter 13 bankruptcy. In the first video, we talked about the three main requirements of a Chapter 13 plan of repayment. One of those requirements is that over the life of the plan, you have to pay back at the very least what your creditors would have gotten in a Chapter 7 bankruptcy. Now, what did they get in a Chapter 7 bankruptcy? The dollar value of your non-exempt assets, because the non-exempt assets would be seized and liquidated by the Chapter 7 trustee to repay the creditors. As I said in that previous video, in a Chapter 13 you keep everything. No trustee is going to take your possessions, because the trade-off is you're going to be repaying your creditors at least as much as they would have gotten if your assets had been liquidated. Now, how do we determine that? Well, on the day of filing the petition, in the bankruptcy petition, we list literally everything you own or have an interest in. And all of that stuff goes into a bankruptcy estate. Now, we take stuff out of the estate using exemptions. And in California, we have two exemption tables, one for homeowners with equity and the other for everybody else. But there's something else that goes into the bankruptcy estate. In a Chapter 7, if during the 180-day window immediately after the day you file your bankruptcy papers, you become entitled to receive anything by inheritance, bequest, devise, or life insurance, that too goes into the bankruptcy estate. And in a Chapter 7, if we can't exempt it, it is fair game for the Chapter 7 trustee to seize for the benefit of your creditors. Well, you may remember I said in a Chapter 13 you keep everything, but this additional contribution into the bankruptcy estate does get factored in. And in the Ninth Circuit, where we are, the state of California is one of the states in the Ninth Circuit, there is a relatively recent holding of the Ninth Circuit Court of Appeals that says that the time period in a Chapter 13 is not 180 days. Instead, it's the life of the plan. So, if you were in your plan for 200 days and your rich Uncle John died and left you a pot of gold, you wouldn't be able to say, well, that money is not a part of the bankruptcy estate, because, in fact, it is. Anything you become entitled to receive by inheritance, bequest, devise, or life insurance during the life of the plan becomes part of the bankruptcy estate. And unless you already have a 100% plan, once you become entitled to receive that, and then you do receive the money, the Chapter 13 trustee assigned to the case will probably file a motion to increase your plan payments because you now have become able to pay more. So what I tell my clients is, in a Chapter 7, make sure the bodies are all still warm for the 181 days after the day we file. And, in a Chapter 13, make sure your rich Uncle John is taking his vitamins for the life of the plan. If you have any questions about Chapter 13, please give me a call at 562-777-9159. This is Nick Gebelt, signing off.